St. East General Counsel, Art Schuerman, and Brett French, St. East Counsel. We are very, very clear on the fact that this is a very popular topic with folks because we have a really impressive number of registrants for this. That also tells us that this is a topic that really matters to you, that you want to know more about. And so, like many of the professional learning events that we do, it won't just be a one and done, but we will look at the topic today. And then hopefully again, in the future, we will continue to explore this topic if it continues to be one that people want to hear about and learn about and know more about. But we will get started today with the best possible folks that I know. It's just great to have Art and Brett here, and they're going to do a combination of information about student investigations, and they're also going to be sharing actual scenarios that they become familiar with around student investigations. It's a complex topic. It's one, I think it's fair to say, that causes a fair amount of stress to you as school leaders. I know that when I was a principal, it was one of the topics, even back then, in a much simpler time compared to now. It always felt like, well, this is another one that I didn't learn about in principal school, so we've got to learn it someplace. So we hope that this hour is informative and helpful to you. And I know it will be, because right now I'm going to introduce my good colleagues, Art and Brett.
Art, you're muted. Hey, Art, you might be muted.
I'm sorry. Okay, I'm back. Happy New Year, everyone. I'd like to point out that about a year ago, Brett and I started thinking about what should we do for the clients in terms of the calls we're receiving, and a lot of the calls dealt around investigations that were done and criticisms levied against administrators. So between Brett and I, we have probably about 50 years of litigation experience. So we decided to kick around the idea of offering this particular presentation. We could spend a lot of time on just practical stuff, but what we want to do is touch upon the practical and give you real case scenarios of things that have happened and have you start thinking about those things when you have investigations that you're called upon to perform, all right? One word of caution before we kick off. Brett and I are very smart. We're very good at what we do, but we are not the school lawyer. The school lawyer is going to be in communication with the board, and they're going to ask the question, well, did Mrs. Jones ever consult with you, school lawyer, about this situation? So what we tell you is good advice, but in terms of what I would recommend is that you contact the school lawyer after you speak with us just to confirm the advice that we gave you as you implement the investigation, okay? And make sure you do it in writing, because there'll be a time during the presentation I'll mention when it wasn't done in writing and what happened as a result of that. All right, we'll move on to the first part of this. Brett, thanks. Okay, that's just our label for this presentation. This is the legal team. We also have 2 other lawyers on staff and regional counsel throughout the state. And okay, legal obligations: conducting a prompt and thorough investigation. As building leaders, it is imperative that you oversee and conduct investigations, all right? And one of the problems I see a lot of people make a mistake from the inception. They don't look at what laws involved, what are the obligations, what do I have to do? And so you have to, when you first get the complaint, is this a DASA complaint? Is this a Title IX complaint, a Title VII or VI complaint? Also, you have to look at the board policies and regulations. A lot of people don't do that. That is what you're going to be held to in terms of the local standard. Does the code of conduct get involved with the student complaint here? Most times they will, as well as DASA. And then from there, a very important thing. Well, the victim didn't come to me, so I'm not going to do an investigation. That's wrong. If you receive information from whatever source that something happened, a bullying incident, a violent act, you have to investigate it, even though the complainant is reluctant or refuses to get involved. The last thing I would point out to you is, well, the two things on this particular area is New York just enacted a new labor law statute. What they did was they took public schools and BOCES and made them required now to have a workplace violence prevention policy and program. So in the next couple of months, your school districts and BOCES are going to talk to you about, we have to create this policy, we have to create this program, we have to do, our due diligence in terms of training the staff and record keeping. It will probably fit pretty tightly into your code of conduct and your DASA, but it's again, another layer of regulation by the state. And one other thing on the bottom of the slide, whenever you do an investigation, you have to keep aware of, are there FERPA implications involved here? And there was a decision made by the United States Department of Education back in 2017, which basically said that the Department of Education views surveillance tapes or videos as having the potential of containing student information. So you have to look at those kinds of tapes and evidence through the idea of, can we redact the other students involved? Can we segregate out that information? And sometimes you can't, but you have to be cognizant of it. And remember, the accused student, if the investigation results in a disciplinary finding and a recommendation of discipline, is going to be entitled to get that footage and that video. You're not going to be able to say, oh, it's FERPA, we can't give it to you. They're entitled to it. All right, so we're going to move on now, and Brett's going to take over a very important area.
Yeah, thank you, Art. I appreciate that. Good afternoon, everybody. If you haven't had the opportunity to meet me just yet, my name is Brett French. I joined Saney's about a year and a half ago, so I've been working with Art closely. Just wanted to introduce myself quickly, and hopefully I do get to work with all of you more. Forgive me quickly, I was going to reshare the screen. For some reason, I needed to pop out so I could see the Zoom screen once more. Let me go ahead and share. All right. So thank you for that, Art. This next section we're dealing with is something that comes up, I think, more frequently than we would like it to, obviously. It's a different type of investigation, and there are different requirements that are going to come up. And that's when you have issues regarding abused and maltreated children. So obviously we understand that as administrators, as teachers, and those with certifications, that we are required and are by law designated as mandatory reporters. And when we must report is a situation that comes up pretty frequently. It's a question that Art and I get asked often. The standard is when there's a reasonable suspicion to suspect the child is abused or maltreated. What does that mean, right? Well, most of the time what we're going to say is, go with your gut instinct. If you're asking yourself the question whether or not I should report this, you probably should, right? But going back to that age-old rule that Art started off with, Art, myself, as Saney's counsel, we're going to provide you advice in the moment. But at the end of the day, you're also going to want to look for the direction from district council, as well as your superintendent. Very clearly here, when in doubt, file the complaint, make the phone call to the hotline, and allow the process to take place. A scenario we'll discuss a little later on deals with a situation regarding a failure to report. I think one thing we want to always remember is that when we have this duty, this requirement to report, that duty is not delegable. Okay, we're going to want to make sure that though we think a teacher may have covered it, though we think a school psychologist may have covered it, we want to be sure that our administrators were either on that call or followed up with their own call or were copied, right, in some form to ensure that that call did take place. Again, best practice, confer with the school district leadership, district council, and also the school resource officer. Depending on the school district and depending on the relationship the district has with local law enforcement, there may be a secondary protocol that takes place at your school district that might not necessarily take place at another school district. We've seen schools that are highly connected to the local county sheriff's department. Sometimes you might have your own village police, your own town police, or the district might prefer to go straight to the state police if there's an issue. So keep that in mind. And while you have your own requirements, also make sure you understand that the school might have a path for you to take as well. All righty.
All right. Thanks, Brett. Just 2 points about the neglect of children and abuse of children in the educational setting. I always recommend using the state hotline, not the local county. Unfortunately, I had a situation with a client who had made a local complaint of neglect or abuse, and that complaint, surprisingly, was smothered by the superintendent because of a relationship with the accused parent. So I always recommend going through the state hotline. The second thing that we've seen recently in the Capital Region, for example, is the local DAs have been telling school districts and child protective services that they don't want the children interviewed by them. They would rather have them interviewed by trained investigators from the DA's office. So that's something else, depending on your jurisdiction and what county you're in, you have to be cognizant of that. All right. Moving on, for the Dignity of All Students Act. This is probably the bulk of your student investigations. And I'm sure everybody understands the statute, which is in the ed law, prohibits discrimination and harassment in the school environment, and prohibits bullying of employees or students, or by students, or by students or employees of students on school property, at school events, and the protected classes. It is so broad when they use the term actual or perceived that it's pretty much almost anything now, that you have to really discern, if you will, the negative. What isn't a DASA type of an investigation? Clearly, all of you have DASA policies and procedures. You have to acquaint yourself. Each building has a DASA coordinator, and you have to understand that. What most people don't realize, and this is where some people get tripped up, is that all employees are obligated, if they witness or receive information, to orally report that to the DASA coordinator in their building within a day, and then file a written report. I chance to imagine a lot of the teachers' aides don't fill out the report properly. But if you get wind, you must begin to investigate. Brett, could you switch to the next slide, please? Okay. And this is the important part up here, is requires school personnel to notify the appropriate law enforcement if the harassment, bullying, or discrimination constitutes criminal conduct. Now, one thing I would tell you, and we're going to talk about this a little later, is when you invite the police in, the ability to interview students changes drastically. Because in the school environment, you as the administrator can question the student. I bet you should know that. But if you bring the police in, if they're under 16, under the Family Court Act, you have to notify the parents before you can interview the student. So that's something you'd have to consider. Also, search and seizure. If you have the police doing a search and seizure, you have a heightened level of review, which is probable cause, whereas in in a school environment, you have reasonable suspicion. All right. The key, if I could get you to remember one thing from today's lecture on as far as DASA, when you receive that complaint, you must promptly and thoroughly investigate it. All right. And you have to take appropriate action. All right. You can't just sit on it, take weeks to investigate it. It doesn't cut mustard, and you're going to subject yourself to liability as a result of it. All right. Also, I'm sure you know this already, DASA-related reports are filed every year annually as part of the school district's violent and disruptive student incident report, i.e. the VADER report. So you have to be cognizant of keeping good notes and reports. All right, Brett, you ready?
Yeah. So as Art noted earlier, when reviewing a complaint that comes in, first things we're going to do is look at any laws that might be implicated, right? The next thing you're really going to want to look to is whether or not the code of conduct of your district comes into play. Now, every school district, as you all know, must have a code of conduct. If you don't have it readily available, oftentimes, if not always, they'll be on the school website. Keep this in mind. The code of conduct is really going to describe ultimately the process of the investigation on behalf of the complainant or the respondent, the person accused, and potentially the target of the investigation. Keep the code of conduct in mind, right? We want to ensure that not only are we following the law and investigating in accordance with Title IX, Title VII, DASA, but that you're also doing so in accordance with your code of conduct of your school district. Oftentimes the code of conduct will set forth the progressive disciplinary procedures for violations. It's not a question we get all that often, but obviously it comes up when determining an outcome of an investigation. Sometimes that judgment call, that decision is hard to make. What we're going to first oftentimes do is direct you back to your own code of conduct, direct you to your school council, your school superintendent, as well as look to how the code of conduct has been interpreted in the past. Unlike DASA, unlike Title IX, where there's going to be state and federal precedent for what is right, what is wrong, in what is reasonable for an investigation, your own code of conduct and how you interpret it really will look at past practices. So keep that in mind as well, especially when determining disciplinary outcomes. So getting into the kind of the meat and potatoes here, when we're doing an investigation, right? The three things we want to address and always keep in mind, right? We want the investigation to be prompt, we want it to be fair, and we want it to be thorough. So Art touched on this recently with regard to the DASA statute and how a complaint must be reviewed and responded to, and promptness is essential, okay? Obviously, you need to gather the appropriate facts before you, but when receiving a complaint, the first thing you're going to want to do is to determine the scope of the investigation. Now, that's a bit tough of a question to start with, but that's a good analysis to start with. And then likely what you're going to end up doing is coming back and saying, was my scope too narrow? Was my scope too broad? But obviously, when you start that investigation, you're going to want to think what laws, what policies, district code of conduct elements may apply. Okay, you're going to want to think, is this a potential disciplinary investigation? Okay, is this a personnel? Is this going to involve personnel? Okay, who is this complaint? Who is the complainant? Are we receiving a complaint from a parent, from a student, from a fellow colleague, right? Now, some of this information is going to be obvious to you, but when thinking about the scope of the investigation, you're going to want to lay these factors out because it's going to guide you throughout the investigation, right? If we have a complaint coming in from a parent, the investigation might look a little different than if you have a complaint coming in from a staff member, right? because you're adding in some outside elements. You're adding in, factors or stakeholders that are not necessarily in your building, that you might have to arrange for when you can communicate with these individuals. And again, coming back to our three, main pillars here: promptness, fairness, thoroughness, right? So you think, can this investigation lead to discipline? Obviously, that's going to be with regard to whether or not you have a student who might be complained of for doing something that violates your code of conduct or otherwise. You're going to also potentially think, is this something that involves a colleague or staff member that might need to be run up the chain of command here? So there can also be a disciplinary aspect to this with regard to their employment. Of course, do you as the investigator have a conflict of interest? Now, a conflict of interest is, again, one of these judgment call issues, right? We all have conflicts, but is the conflict in such a way that it would prevent you from conducting the investigation in a fair and impartial way? Again, one of our pillars here, making sure that investigation is fair. And the reason we do stress that is not only to produce a proper outcome, but to insulate yourselves. These are oftentimes high stress situations with a lot of emotion from the stakeholders that are involved, right? You want to make sure that you also provide them with the support that they're looking for, right? While also ensuring that you're doing what you need to do as an administrator. Something that, Art definitely, with his years of experience, can talk about for days and days is, are there political, legal, or wild card considerations? You all know what that means, and it means something different for each of you, right? You're going to want to understand necessarily who could be involved in this investigation. Is this something that is being complained of that could possibly get out to a news outlet? And really, this consideration here is not to influence how you conduct your investigation from a perspective of, I'm not going to talk to that person because their hands are they're untouchable. I can't go there. No. What it is going to do, though, is it's going to allow yourself to evaluate the situation slowly enough to make sure that your superintendent is informed. Make sure that your school council is aware. At the end of the day, the last thing you want is a curveball being thrown, something popping up on the news, and your superintendent saying, I never even heard about this, right? So, and by the way, that might happen and you're not even done with your investigation. So now is your investigation going to end up being prompt? Are you going to be as thorough as you want it to be? Will it result in a fair outcome? So thinking about these considerations is not to change or alter what ends up happening in the investigation, but it's to make sure you have the proper people informed, and that you, if you need to, use child gloves when you need to use child gloves, right? And obviously, the last thought that I kind of touched on here: do you need to inform the superintendent of the complaint? This is definitely a judgment call. As many of you know, at every presentation Art's given, he always follows up with, when in doubt, let the superintendent know. And that's a good rule, right? There are going to be times where maybe you can't let the superintendent know for whatever reason. Maybe it's because of how prompt the investigation needs to be. Maybe it's urgent. Maybe you have an emergency on your hands. You've got the school resource officer involved, and you need to make a call. You need to get things moving, right? Well, make a note. When do I come back to letting the superintendent know? Okay. Whether it's, tee up an email that you need to send off later, or think to yourself, if it's not the superintendent that I need to notify or should notify about this, who else can I notify to bring in the loop to both insulate yourself while conducting the investigation and make sure that those in, district office are also aware of what's going on. Okay.
All right. What constitutes a fair investigation? Well, let me give you an example of a situation. If you receive evidence of bullying, abuse, discrimination, harassment, it's got to be investigated. what happened in the case recently, which I thought was interesting, is the principal is notified by teacher, oh, student A was inappropriately touching student B. And so the principal starts the investigation. And one of the things he learns almost immediately is that student A had done it before and the teacher never reported it. Now you have an independent obligation then to do what with the teacher? To counsel them because they failed to follow, the, again, abuse or neglect in the educational setting. So the moment you get the notice from whatever source, you have to investigate it. And it has to be done as soon as possible. I mean, we're just trying to stress these things to you because it is very important. And that means, well, I'm tired, it's Friday afternoon, and I really don't want to look into this. I'll do it on Monday. That's probably the wrong answer. You want to look at it now and at least set up your investigation for the following week. Also, whenever you talk to witnesses, you have to stress that what they say to you is confidential. And the reason for that is twofold. One, then if they go around blabbing about it, they can get in trouble. But also, it provides the witness with a sense of security that what they say will not be exposed to other people. Now, obviously, you cannot, if it's the victim says, Johnny Jones, groped me, that Johnny Jones, when you eventually interview him, is going to know that a student said you groped them. So you have to let them know we're going to maintain confidentially to the greatest degree possible. Also, every witness, and especially the accused, has to be instructed that there shall be no form of retaliation. And retaliation can be directly by the accused's friends, supporters of the accused. So you have to, as you go through your investigation, be mindful to tell everybody no one should be retaliating against anybody else. Okay? Obviously, we'd all like to have complaints in writing. And if the victim is reluctant to put it in writing, you still have to investigate it. It's not one of these situations, and I've heard this a few times, well, they never put it in writing, so I didn't investigate it. Wrong answer. You have to investigate. The moment you know, you're going to be held liable if you don't investigate it. And good attorneys like Brett and I will rip you apart on the stand for why you didn't do things that the policies and regulations spell out. Okay? I would tell you this is very important. And Brett and I tackle every case that we have with meticulousness. Every stone has to be uncovered. So if you're gathering evidence and they say, oh yeah, there were emails, there were texts, there were IMs, there were whatever the evidence is there video, is there social media? You want to be able to try to recover that evidence and make copies of it, okay? That's very important. Now, one thing that I have seen, and this happened 2 years ago, a school lawyer was told by an assistant principal, I have these images of a student taking naked photographs of another student. What do I do with them? They got bad advice. The school lawyer told them to destroy the evidence. And then the lawyer tried to lie. The good thing for the assistant principal, he had the principal in the room. So it was clear the two of them weren't mistaken about what was said. But that is evidence. Now, if you have, it brings up to another question when you're gathering evidence, is certain types of evidence, and we're going to talk about this a little later, has to be preserved, but how should it be preserved and under what circumstances? That we'll talk about in a few minutes, but you got to gather all the evidence. I think the hardest part of an investigation, quite honestly, is going into it without a conclusion already. You have to be guided by the witness testimony and the evidence. Don't come in with predispositions on what you think. Oh, this is a bad kid. I think he did it. No. You got to look at it like a tabula rasa, which means a blank slate, and listen to every witness testify, look at every piece of documentation, and then after all that, you're going to make a determination. Tied into that is interview every witness. If any witness has even a circumstantial piece of evidence that ties or doesn't or refutes what was said, you need to interview that person. Again, you're going to measure them for bias, prejudice, consistency in their story. All right. And the most troublesome part of this is I get people calling me, oh yeah, I did this investigation. Well, let me see your notes. Oh, I didn't take any notes. You should take notes of everything you do in terms of any investigation. And there are two reasons for it. One, it provides you with cover when somebody says you didn't do the investigation right. And secondly, it helps refresh your recollection if there's a civil lawsuit 2 years later and you're trying to remember exactly what you did and what order you did it in. So always keep contemporaneous notes of what you're doing. All right, I'm going to pop it back to Brett regarding representation during investigations.
Sure. So contrary to what maybe you might think, students do not have the right to be read a Miranda warning, have Miranda rights when they are being questioned. So our administrators have the right to question students, and that student does not have the right to have an attorney present with them, nor do they have the right to have a parent present with them. Of course, if they decide not to talk, that's their prerogative. Something to think about and always keep in mind, there really isn't any other than your standard constitutional protections and kind of how I just described them and how they interplay with that questioning. But something aside from your constitutional thought process there is really to always look back to your code of conduct. Your code of conduct may spell out that process or may spell out a different set of rights that are above and beyond your standard constitutional rights. Okay. Keep in mind that employees may be required to cooperate in an investigation. I'm sure you've all conducted investigations where you have had to question a colleague or a member of staff. And sometimes it's simply for information. Sometimes it's because they're at fault. It's an unfortunate aspect of being an administrator at times that you have to have the heavy hand. But if there is an issue that you deem to have been, wrong on the part of that member, that employee, that staff member, that teacher, you have to write them up. You have to counsel them. Every district is different with how you go about doing those counseling memos, whether you need to run it up the chain of command, whether you need to document it by an email, whether it needs to be formal through the school council. So definitely always look to the practice of your school district. But something that we see, Art and I deal with consistently is a secondary investigation into our administrator who, when conducting their own investigation and arriving at an outcome, failed to document that outcome and failed to counsel the staff, the employee. Like I said, it's an unfortunate aspect of the job, but to fail to do it, it prevents that third pillar, that thorough investigation from taking place. Because now you don't have an opportunity for that person to be mentored, counseled, and for behavior to change. Now, keep in mind, students are protected while they might not have Miranda rights, and that stems from the fact that you're not police officers. But students are protected by the U.S. Constitution from unreasonable searches and seizures. And of course, I think we probably all think about strip searches when we hear searches and seizures, but that really would apply to any type of search of the student's person, right? Which could be their backpack, their jacket, their pant pockets, right? And in order to conduct a search, you need a reasonable suspicion that search will produce, evidence of a crime or evidence of the violation that you're investigating. Okay, it's not the same thing as probable cause, so don't get too deep in the weeds there. But it's a reasonable suspicion. So, a word to the wise: when conducting your investigation, we keep talking about documenting your investigation. Document your notes. Why am I talking to this person? Why would I have required a search? Why? What prompted me to request this search or to pursue this search? Who provided the information that alerted me to the potential that this student may have, contraband on their person, a weapon? document those things. Obviously, in the moment, you might have to document afterwards, right? But go back to your notes and be sure to discuss what your reasonable suspicion was based on. And that's going to help insulate you, and that's going to create a thorough investigation. Number 4, our strip search is legal. We all understand, but to reiterate, no, they are not legal. Okay, from your perspective as an administrator, there's an elevated standard even for an officer or to do that. So if someone else tells you they're legal, they're not. Okay, if someone else wants you to conduct a strip search, give us a call, but that's where you're going to draw the line. That's not going to be your responsibility. You're not going to do that. Okay. All right, conducting witness interviews. I'm going to scoot through this to an extent kind of quickly here. We definitely want to leave a sufficient time at the end to go through scenarios and questions. Art talked about a good amount of this. Obviously, interviews should be conducted in a confidential environment. Confidential, but you're likely always going to want to have a second person with you. That's basically a golden rule that we always stand by. With that said, each interview should be held individually. That's to stay any conflict of interest or any poisoning of the well, right? You're going to want to ensure that the person you're questioning, you don't also have the friend or another colleague listening in while they're being questioned, right? Kind of common sense, but it happens all the time, okay? You're going to want to, that's going to help avoid collusion. It's going to help ensure that this investigation continues to be perceived as fair and thorough. Of course, you're going to want to advise the witness to keep what is said in that meeting confidential. You're also going to want to advise them that they should not retaliate against anyone else, and they also should not be retaliated against for participating in this investigation. Some more common sense here, but you're going to want to start your interviews with the complainant. Of course, that's the person making the complaint. You're going to want to ask open-ended questions. That goes hand in hand with what Art described as going into this investigation with not having a preconceived notion, right? Very difficult to do. I've been guilty of it before. I start a conversation with a member asking me for some advice, and I'm already, asking yes, no questions, leading them down a path and not realizing that I'm not letting them tell me their side of the story. I already have a preconceived side, determination as to what probably happened to them because I'm trying to get to the answer and help them, right? We have to let the information come out naturally. And a lot of times by doing that, they're going to give you the information you need, and they're going to give you the information you didn't know you needed, but you do, okay? Again, avoid predicting the outcome. Ask for relevant documents and possible witnesses. These question and answer situations are not just to get the answers out of that person, but they might lead you to the next witness, right? Interview the accused after you've interviewed all other witnesses. This is something that Art and I have seen actually, more frequently than we would think, is the accused being interviewed prior to some other witnesses being interviewed. And what that can do is, again, you can poison the well. You can also prevent a thorough investigation from taking place because you don't have all of the information. You don't know the questions to ask that individual who's been accused. Obviously, when you speak to the accused, doing so at the end of your investigation, it might open up new channels, new avenues, new witnesses to speak to. That's fine. That's going to happen. But really don't speak to that accused until you think you have sufficiently come to a near conclusion of your investigation. If doors open, then you have to go through them after that. And that really goes into number 9. Determine if you need to re-interview any prior witnesses or newly identified witnesses. Something really positive to do is at the conclusion of any witness's interview, as the investigating administrator, you want to really ask them, is there anything else I've missed? Is there anything else you want to tell me? Art and I will tell each of you, whoever contacts us, to come sit with them if they're being the target of an investigation or a witness. Those are the opportunities you don't say anything more, because usually that's when the beans get spilled, right? But that's a great question to ask as an investigator. Is there anything I missed? Is there anything you have questions for me? You know, you can go through each of the witnesses that they have brought up, make sure you've got their information accurate, and go through and say, do I have everybody? Is there anyone else I've missed? You're going to want to make sure you have your dates, your times, your locations, all accurate. And that's going to be, while you're keeping these contemporaneous notes, you can go back through that. Of course, with regard to incidents of abuse, this is something that you really need to keep in mind. When investigating an incident of abuse, I think we're ultimately always going to be most interested with that single instance of abuse that we've just heard about, right? But something we're going to want to know is this a repeated behavior? Is this something that student or that family member is going through frequently? Because obviously that's going to change how you conduct your investigation. Of course, it's something that we always hear from in the insurance industry, if anyone knows any insurance attorneys, or but the first thing an insurance attorney does in a deposition is they will gauge the makeup of the witness. Okay, how are they dressed? How do they respond? Do they fidget? Are they confident? Now, we don't want you to psychoanalyze every individual, but those types of analysis are important. Make note of that. Is this an individual that seems confident, seems trustworthy? Do you believe that they are being forthcoming? It is your job to investigate. You can have an opinion as to that, okay? And document those opinions, because that will be helpful down the road. I think also it is important, this is from a perspective of supporting that individual when questioning the complainant. But you're going to want to question the complainant as to, their emotional, affect, right? And how this has impacted them. That's going to both prompt you as to know where to go with this investigation, but it's also going to highlight possibly any services that person might need. There's information that you're going to learn in an investigation that, while you need to maintain confidentiality in that investigation, you might need to be also bringing in additional stakeholders, seeking resources for those individuals, right? And that is a job that is going to all fall on your shoulders. So you're going to be going to be wearing multiple hats, right? You're the investigator, but you're also going to be making sure that student, do they need a safety plan in place, right? Do I need to be getting the school psychologist involved? All the while maintaining FERPA protections, right? So that it's a lot, but keeping in mind these different avenues, right, is going to be very helpful.
Thanks, Brett. Just a couple of things on just the questioning itself. I think you get more bees with honey than you do with vinegar. So be polite, be respectful, all right? The types of questions you ask are important. So ask open-ended questions. What an open-ended question? How, when, why? Those kind of questions. Where? Who was present? All right? Don't ask leading questions, because leading questions, you're already concluding something. Just ask those how, why, when, where kind of questions. Also, don't ask compound questions, because it gets confusing. And you may have to write out your questions. That's all right. Just if you feel you need to, that's fine. Also, don't ask questions like, so were you bullied or harassed? Two things. It suggests a conclusion to them, and also they may not know what the legal definition of something is, and that's actually your job to do. One of the things I would tell you always, don't come across like really aggressive on the witnesses, because witnesses may perceive that as they're being accused of something. And if you're trying to get the witnesses to tell you something truthfully, always be polite and respectful of them. All right, next slide. Assessing witness credibility. Brett did a good job. I would just add a couple of little things. I always use this in the DA's office when I was examining witnesses. And I mean, this is before they were indicted. If the witness always looks down to the left, they're typically lying. Okay, so keep that in the back of your mind. All right, another one. How did they react when you confronted them, and this is typically with the accused, with evidence that contradicts their story, or a witness for that matter, or they gave an inconsistent statement. And when you say, well, you said this before, and now you're saying this, and if they don't come, truthful about their explanation for the inconsistency or the contradictory evidence, then you probably will decide not to give them much credibility. And that's part of your assessment, and that's fine. One thing I would tell you to do is remember, these people will be nervous, some of these people. So you have to factor that into when you're determining credibility. All right, Brett.
What not to do during an investigation. We touched on several of these, but I think first and foremost, ignoring the complaint. This happens, okay? We get calls about this frequently. We get calls about our administrators who got a complaint, never addressed it. Not only, did the buck not, get passed to somebody else, but it just never even got picked up. Okay. That's number one. Just can't ignore it. Number two, it goes hand in hand, though, is delaying conducting an investigation. Or hit the nail on the head. Doesn't it always feel that a complaint is coming at Thursday at 4 p.m. or Friday afternoon, and you get a long weekend, and ultimately common sense or human nature says, hey, this can wait until Monday, we're off, or it can wait until after the long weekend. Ultimately, you cannot delay that complaint. We all know, especially DASA complaints, right? You're dealing with instant communication technologies with social media, Snapchat, all the above, right? At the very least, a plan needs to be put into place. The right stakeholders need to be notified. Of course, conducting an investigation and, playing Monday morning, quarterback, looking at how the investigation was done, it's always going to be looked at in a reasonable fashion, and if you have gone and done what you can and contacted the right individuals to lead into a proper investigation, of course, that's going to be looked at favorably. Something that is essential, is being available and being able to be communicated, especially if you have an incident that you learn of and there could be abuse and you're heading into a weekend. You need to be able to be contacted by the police, by the superintendent. So while we all want to have private plans, unfortunately, that might draw into your weekend. That's going to be necessary to keep up with. Of course, interviewing witnesses, I'm jumping down, but interviewing witnesses together, this happens frequently, and I think it happens probably more often negligently, not intentionally, but what ends up happening is, you get a complaint, and prior to assessing the complaint and walking through those steps of planning out your investigation, you make a quick move, and you have 2 or 3 people that might be involved, and they're already in your office and you're talking to them about it. That happens. We understand sometimes these things are a lot smaller, sometimes they're bigger, right? Do your best. Don't speak to these individuals together, right? That's going to be just a major fault, and it really will throw a wrench into the process producing a fair result. Because at the end of the day, if a discipline results, you're going to have to stand by that discipline, right? Yeah, ignoring exculpatory evidence, right? If we have evidence that points otherwise from, witness 1, 2, and 3, from what they're saying, don't ignore it. Okay, you're the finder of fact when you're conducting these investigations. So, understand how to assert, credibility to evidence and to witnesses. Okay, all right. Concluding the investigation. This is something Art touched on, but keep your records, keep your investigation notes. Okay, I don't know. Art and I have been kind of batting it back and forth whether we think you need to really take a hard look at whether you want to have electronic files of your notes, okay? Whether you want to convert your handwritten notes, scan them, copy them, ensure that they're in a protected location, but keep your notes. That's going to allow you to then prepare a written report, okay? Detail your investigation, detail the process, detail who you spoke to, and the key facts, right? Then you're going to want to come to a finding and a recommendation. Another issue we see constantly is an investigation gets started and no outcome. It's never resolved. And ultimately, that's going to come back on the individual who conducted the investigation, right? Then you're going to want to advise the complainant of the outcome. Of course, with regard to advising the complainant of the outcome, you're also going to want to, take into account, especially if this is dealing with an employee. Okay, what's my next steps? I've made a finding here. Now, do I need to counsel them? Do I need to run this up the chain of command? Okay. Of course, you're also going, if it's a student, you're going to advise them of their rights. Look to your code of conduct. It probably is built into your code of conduct that they always need to be provided a copy. Have copies of your code of conduct readily available. We understand they're always printed on your website, and usually you'll say, you can go to the URL here on this sheet. Have copies of your code of conduct readily available. You never want to be in a situation where you didn't have that readily available. Okay. Of course, report to the necessary school officials, building principal, superintendent. Preserve your investigation notes. General practice, I think we all understand and have heard, is usually 7 years, right? Accounting records, taxes might be a little longer, so I don't want to speak on that. 7 years is what we hear. Hey, we're involved right now with certain DASA complaint issues looking back several years, okay? That's a bit of a judgment call. I think 7 to 10 years is a good rule of thumb, but preserve your notes, preserve the outcomes, preserve your communications dealing with the investigation, okay? All right, let's get into some scenarios. I think Art's gonna take the first few here, and then we'll take some questions.
All right, what we're gonna do here, Brett and I, we're gonna go through these, and we want you to understand that this is a good way or a process or a procedure to do this. So if everybody could just quickly read this first scenario. I'll read it quickly. In a suburban school district, the teacher was friends with a board member. The teacher and board member have high school female children. The teacher has babysat the board member's child on many occasions. The board member asked the teacher if she would allow the board member's daughter to stay at the teacher's house when the board member and her husband go to the Dominican Republic. Shortly after the board member's daughter stayed at the house, the teacher's daughter reported to the building principal that the teacher had given alcoholic beverages to the board member's daughter when she stayed with the teacher, and let the board member's daughter's boyfriend come over to the house when the alcoholic beverages were served. So the first thing I would look at is this is obviously off-campus conduct, right? Second thing is this is political, isn't it? You're involving a teacher. You're also involving a board member. So thinking of this methodology we've been talking about, I don't think anyone here would not at least call the superintendent and say, you may want to be aware of this investigation I'm about to conduct, okay? The next thing would be when you're conducting the investigation, you should obviously, the person who makes the complaint is the daughter. So you would want to interview her first and get the details. Now, one of the things I would tell you, if you're interviewing the teacher's daughter, the thing that would strike me right in my mind, I have to stop is all the top. Why is she making a complaint that could harm her mother? So I think you'd want to probe that from a bias or prejudice. Is there some sort of bias or prejudice here? Did she not get a new phone or allowed to have a new iPad or something? Or is there some motivation that would make her make a false statement? If there's nothing like that, and you quickly determine that, then you have to assess her credibility is going to be stronger than a normal witness in that sense. The next thing, obviously, in this type of investigation, you want to interview the teacher. Now, remember, the teacher may have the right to union representation if they're tenured or not. It could lead to discipline against a teacher. Obviously, you would want to interview the daughter of the board member, the boyfriend, right? These are 4 people. You would also want to talk to the board member. Did you talk to your daughter when you came back? What did she say happened during that time you will, that you were away? Now, if you're getting the inclination that this could result in maybe a criminal case, obviously serving alcohol to a minor is a crime. It's a misdemeanor in New York. So you may want to refer this again with letting the superintendent know, listen, this may be a criminal case. I think we should alert the police. Now, what happened in here wasn't any of what I told you. Basically, he just interviewed the student who made the complaint and then asked the teacher and the board member's daughter who denied it. The police were ultimately called in. And I think many of you who attended the conference know what happened. In this particular real life case, the teacher had plied these kids with alcohol and I think marijuana and then filmed them having sex. So the teacher lost her license, was convicted and arrested and the whole thing. But again, we're trying to give you the methodology on how to attack these cases. So I would tell you, think about that from the ways I described it. All right. This one, I can tell you, this is an urban school district. A parent of a student reported to the administration that her daughter was forcibly imprisoned and forced to perform oral sex on a male student in the music classroom. This clearly is criminal conduct. So the first thing you should do is what? Hotline this to the state hotline. The next thing, you notify the police and let them conduct this investigation. All right. That was not done here. And what was the other problem in this was the accused parent worked in the school district, and Brett talked about this before. Appearance of a conflict of interest arose because of that. That's another reason why if that choose family member works for you and you're the investigator, I think you have the right to tell the superintendent, I do not want to conduct this investigation to avoid the appearance of impropriety. I think you should have somebody else do it or an outside investigator look into it. So those are the couple of things in that case I think it's important. I just want to jump to the third one quickly. All right. This one turned out to be a major case in the press. In a large city school district, 3 students are seen entering the bathroom. They exit the bathroom and they're visibly high. Another student advises that the students had tried to attempt to sell her drugs, but she declined. So the principal and the assistant principal, armed with 3 students who are intoxicated. One student informs them that the students tried to sell her drugs. So there is, again, a nexus to what happened, i.e. the drug sale, potential drug sale, and their behavior. So what do you do with these people? Well, they're brought to the nurse's office, and you know what happens next. Can we search their backpack? I believe based on this information, you certainly can. Can we search pat down their clothing? I think you can. The question that came up is, could the nurse ask them to remove some outer clothing and let her pat them down? And that became the source of the whole media explosion about this. And as it was portrayed in the media was, this was a strip search. And it wasn't a strip search per se, but it was close to it. And as Brett said, we would tell you strongly, unless it's a life and death situation, I wouldn't get involved in a strip search. And certainly if there was a need for it, I would ask the superintendent and the school lawyer what you should do before you do it. All right, Brett, up to you.
Sure. Thanks, Art. Scenario 4. This goes back to that mandatory reporter status, right? And that non-delegable duty. So we have an administrator advised by a school psychologist during a meeting with the psychologist, the administrator, as well as a teacher, that the psychologist suspects abuse and neglect at the home of the student. Administrator believes that he hears the psychologist mention that they are going to report. He thinks the teacher says they're going to report. But at no point does the administrator advise psychologist or teacher of their reporting requirements, as well as acknowledge their own reporting requirement. Ends up that the administrator leaves the meeting and no one reports. Okay. It ends up later coming to the superintendent's attention that many individuals had made complaints to the psychologist and the teacher that they believed this abuse was happening. Okay, superintendent goes to check with our administrator and look at whether or not, when the report was made, and no report was made. The administrator believed that basically everyone else was going to do it. We want to reaffirm this understanding that the buck stops with you and you can't pass it off. Sure, we understand that there can be some duplication. Make that call together, okay? If you're in that room, the psychologist, the teacher, the administrator, you feel that you need to make that call together. But at the very least, make that call yourself, okay? Again, your duty is not excused by thinking somebody else has already reported it, okay? We'd rather you report in redundancy. All right. Scenario 5. Do not draft a disciplinary decision. Provide it to your secretary. Put it in the outgoing mail. Put the address and stamp on the mail, and then change your mind about the decision after speaking to the student and student's parent. Again, also without documenting that conversation with the parent or changing the disciplinary outcome. We had a situation where an administrator who had already been repeatedly counseled about flawed investigations dealing with vaping and also flawed disciplinary outcomes related to those investigations, counseled for a third time. A suspension letter was drafted, provided to the secretary, and then after that decision had somehow made its way through the grapevine to student and student's parent got on the phone and the outcome was changed with no documentation as to why. And also the disciplinary letter still went out. We don't know if it was a fair investigation. Doesn't sound like it was all that prompt, and definitely not thorough. And to reiterate, no records indicated what the conversation was with mom or the accused, why it was had, other than to complain about this potential discipline that was coming. And and there was no notes to speak otherwise. It was just an all-around bad situation. All right, last from me before one final one from Art. Maintain open lines of communication with the school resource officer and police department after reporting potential abuse and conducting some of your investigation, right? We have an administrator who gets some information, believes there's abuse taking place, starts to investigate it, but also calls the hotline and gets the school resource officer involved. All great, right? There's some confusion as to whether or not, while providing that information, the administrator may have identified who they believed was the alleged perpetrator, I should say. That came down to a bit of a difference in opinion, but what I would stress is when elevating a matter to a hotline call or to a police and a law enforcement agency, what you are going to want to do is continue to maintain both your conflict free, right, as well as also not coming to a determination. Remember, they are going to then also do their own investigation. Give the facts you have as you have them. Try not to insert your own opinion in those situations, right? You're conducting your own investigation and you're the only party going to be doing it. Of course, you're going to come to an opinion. But early on, and especially when involving a third party like the hotline or police, law enforcement, you're going to want to make sure you don't provide any type of opinion early on. With that said, you need to also continue to maintain open lines of communication. During that situation, we had an individual, the administrator, go out of cell service, can't get contacted. Okay, the wrong person is investigated, and then the investigation kind of blows up and turns into a sloppy mess from the law enforcement side. That necessarily wasn't the administrator's fault, right? In this scenario, there's a lot of moving pieces. But what could have potentially been done better was continuing to maintain open lines of communication and simply giving the facts without opinion, right? So keep in mind, we have to even be careful with that. You can have done everything right, but then not answer that call and not ensure a prompt investigation is completed and up. Now it's back on our shoulders. All right. Last one for you, Art. You're muted, Art.
No, I know. I said thank you. We had a couple questions, so I was just trying to look at them. But first, the last scenario is an interesting one. A couple of years ago, the United States Supreme Court issued a decision out of Texas. It's what we call the cheerleading case, in which a unsuccessful varsity cheerleader went on Snapchat, gave the middle finger, and basically used the F word to talk about school, the cheerleading team, everything, and then also had an emoji which also contained vulgar language. This case is a real life case. And what happens in this case, so the first thing you got to say is this is off-campus conduct. So this is a First Amendment type of investigation, okay? And the question ultimately will come, is it free speech versus interference with school operations or rights of students? Student A is in his home with student B, and he prepares a statement and sings lyrics in which he uses the N-word that way. Student B videotapes it, okay? And unbeknownst to student A, student B sends the video to student C, who posted on the high school senior Snapchat. Now, remember, Snapchat is a temporal medium. It's there for 24 hours and vanishes. In this particular case, the question is, what action should the school district take against student A? Now, remember, he doesn't identify the school, he doesn't identify anybody, he just makes this statement. Okay, so think about that. Then the second part of the scenario here is student D, an underclassman, sees in that brief time period or hears about what student A does, and he basically says, I'm going to beat him up in fact, tells the high school principal, I'm going to beat this kid up. So what should happen to student D as well as student A here? What do you think? What happened, I will tell you, is this. There wasn't an interference per se with school operations or the rights of students. This was a off-campus, agreed doesn't have much socially redeeming value what he did at all, and in fact is vulgar and discriminatory in a sense. But I would tell you, look at the student code of conduct. I just don't think it would rise to that for one critical fact. He didn't post it on any kind of senior class snatch out. He just did it for his friend. And in that case, the principal researched the law and then called the superintendent and the school lawyer, who both agreed this was not an act that could constitute discipline under this code of conduct. As to student A. As to student D, he threatened to beat up the kid. He admitted to the principal he was going to beat him up. He got a 2-day suspension because he made a threat. And I think the case is, and especially with the commissioner over the last 6 or 7 years, if there's threats to students, threats to employees, particularly administration or teachers, if there's sexually vulgar language being used on a social medium or through text or email, they will be very hard and well, the commissioner will uphold suspensions, basically. So that's something to keep in mind about that. One thing I wanted to talk about, and I forgot earlier to mention it, we talked about sexting, and it's funny, the sexting cases have quieted down a lot from 5 or 6 years ago. But if you got a child who says, Johnny Jones sent me photos of my sister naked, I would tell you, don't download them. Don't ask them to send it to you. I would tell you to notify the police and let them handle that, because the dissemination of sexually explicit photographs of children could be a federal offense. And the first case of this happened about 10 years ago out of Virginia. And in that case, unfortunately, the assistant principal downloaded the images and he was federally prosecuted. So you want to be able to, not get yourself in trouble. So in that kind of case, I think you tell the superintendent, hey, I have to notify the school lawyer, and I think we need to call the police to get access to this kid's phone and download the photos. All right. There were a couple questions.
We do have some questions. One of which was a kind of a clarifier that I've spoken about with regard to maintaining records.
Yes.
It's a little farther down, but I do want to hit it because I don't want mixed message here. So, Mark's right. There is a requirement that the records be maintained until the youngest individual involved in the DASA complaint, I believe, reaches 27. With regard to the note keeping and record keeping, I guess and Art, you can touch on this too. What we're referring to is it's not that you're duplicating these notes, but it's that you're going to be maintaining your own files as well, right? And for DASA, I imagine that your school district will likely have its own DASA files maintained. And if you're the DASA coordinator and in charge of maintaining those files distinctly, sure, you need to ensure that you're keeping those until the age of 27. Our general rule of thumb with simply maintaining standard investigation notes and documentation, though, is 7 years. So I didn't want to contradict that. I don't want to clarify that. But
that's a good catch. And another person had sent an observation earlier about if you have to understand and assess the interviewee who you're examining. Certain cultures, they will not look you in the eye because it's disrespectful. So I think that's a very good point. You have to take every witness as they are, and you have to understand what are their cultural, if you will, mores as you interview them. So what you may conceive in mainstream America is this, in their culture, it may be totally disrespectful to do that.
Right. Now we have a question regarding being trained that nude photos or videos of sex acts should not be viewed by administrators. Typically have the evidence collected by the SRO, which Board of Ed policy allows. If we view child porn, can we be charged? You just spoke on that. Yes, that's correct. You have
Well, no. If you download it, I think
download it to your phone.
You see it, then you just try to make your first act should be to try to preserve it, but not you preserve it because you don't want to download. That's where I would notify
but I would agree with the sense that the advice would be from us. We don't want you viewing it either. I think if you have, of course, if it's if it you're while pursuing your investigation, you discover this and you weren't aware of what you would be looking at or viewing. Of course, that's a different scenario. But if you have information that what's about to be provided to you is a sex act or nude photographs, I think you're correct to think that the first thing you need to do is determine whether you need to involve your school resource officer or the police. Additionally, that is always going to be a situation. Remember, contact your superintendent and or your district council. They're going to have the policy of the district and might take it off your hands from there, right? But you're going to want to loop in your district council.
Okay. Yeah. We had two other questions. I see here. Lisa Thompson asks, what if a request is made to record a investigation interview? Well, first of all, if it involves an employee, you cannot record it. It's a mandatory topic of bargaining. If it involves a student, I would tell you, I would still probably not record a student. I would just, I know it's funny because most of you have been recorded by parents, but I would tell you, if that's where Brett alluded to before, you have a second person in the room. So you can say, this is what the kid said. He admitted it, he did it, or, or take copious notes. I don't think it's a good idea to record it. The other question I see is going back to scenario 7. So there was no disruption to the school environment. Correct. In that case, it was off-campus conduct and it wasn't directed at the school. It was privately retained on in a temporal form, i.e. Snapchat, that somebody else sent up anyhow. So I think the district was correct, ultimately, given its latest Supreme Court case. And by the way, there hasn't been a case since then on this topic of off-campus free speech. This was really the first case in many years that they even addressed at the Supreme Court.
There was an early question here about reasonable suspicion.
Okay, I didn't see that one.
So, Tom Hall, if we have a lot of reasonable suspicion that the search will provide something illegal, a violation of school policy, what do we do when kids refuse to search? We just start searching their backpack without their permission. We have never done that before, but instead we'll suspend them for 5 days for insubordination.
Well, yeah, I would say this. If you have reasonable suspicion that they are carrying a weapon, they have drugs, or other kind of like drug paraphernalia, I think you have to assess what is your source of that information. And then the nexus is that this question is, where do you believe, based on the information you've gathered, this contraband is located? Is it located in their backpack? If it's located on their person, can you do it without an invasive strip search? Those are the things I would ask you to do.
And I think simultaneously consider, calling the police. Obviously, if this is, we're talking, depending on the exigency of the circumstances, right? How urgent is this? But, ultimately, probably the best bet is also going to be running that up the chain of command when you can and contacting the police, right? Was there one earlier than that? Maybe not.
Just to add, search and seizure questions always involve facts. What's the source of the knowledge? What's the source of the or the resulting evidence that you're going to get?
So Lisa Thompson asks if the student can record. So first off, you're going to want to look to your your school code of conduct, right? So New York State is a one-party consent state with regard to recordings. Okay, so one party to the conversation or communication has to consent, meaning that student's consent can validate or provide that level of consent. I think the first thing you're going to want to do is, does your school code of conduct allow for students to use technology during the school day, record? Can they be video recording? From there, I think it's a judgment call. I guess, is it legal for them to? Sure, but can you prevent them from doing so? Or what do you think on that?
I would tell them, well, I know most school districts and BOCES now have policies regarding use of school cell phones in school, and I would object to them recording it. I'd say no, that's not permissible.
I think the other thing I would hang my hat on is the confidentiality of the investigation. Okay, so a recording by that student is going to prevent the investigation from maintaining a confidential nature. Now, they might say, then fine, I'm not going to speak to you, or I'm not going to allow XYZ to happen. Okay, that's fine, right? Deal with that. And I think the prior question is, then they're being insubordinate. But I think that you can definitely hang your hat on confidentiality. I don't know if we talked about this much, but the issue of, the First Amendment and how that's going to come up with a lot of these investigations with, social media postings, TikTok videos, and how that comes into play with conducting an investigation and going about potentially disciplining someone for that conduct. It's something that we have to be aware of and really understand what was the intent of the First Amendment of the speech, right? Is this a video that was made privately in a private home, and you have a couple of kids goofing off and it's only meant for them, or is this being posted to a public, Facebook page to bully, students? So, Art, I know you've dealt with some First Amendment cases lately. Are you seeing any kind of trend there?
Well, I think if it involves attacking the school, attacking employees, bullying other students, any kinds of threats, any kind of sexual, vulgar imaging, even if off duty, I think the schools in loco parente have the obligation, and that's where one of the attendees noted, does it impact the school? Yes. I mean, if you can show the nexus to the school environment or bullying and stuff, and it fits within the DASSA, I think that does. If it's all private and it just basically doesn't go further than that, then I don't think the nexus is there. And especially if it's not identifying a particular person, or it can constitute, like I said, bullying or harassment. Mm-hmm. Like the cheerleader case, she just broadly, condemned the cheer team, but she didn't identify the cheer team. She didn't identify the school district. She just basically was upset, from what I gather, of not making the varsity cheer team.
We had a request to see an example of a DASSA investigation report. Do you have one that's done well that we can compare our work to? That's a great question. I can't determine what that individual's name is. It's RCHENAILL. Trevor, can you, I think Trevor, you're watching this. Can you direct message her and get her contact information? That's something we could definitely look into. Great question to see maybe a model investigation report to be able to use as an example.
In preparation for this particular presentation, Brett and I contacted school lawyers throughout the state. I know some of the school law firms who do provide training on investigations also have samples. I know one in particular just recently told me they made a sample report on how it should be. We at Saney's don't have those reports on file, simply because we don't do those reports. we will look at them
Tends
when
to
they
be your
come in.
district council that'll end up having those, right?
Yeah.
But that's something we can definitely look into and see if we can put our hands on that. That's a great question, though.
If I can just interject there, that's something that we would really like to provide to some of our members, particularly around DASA, because one thing I can say very confidently, we have a lot of mentees who are very new or newer administrators, and collectively, they are really looking for models when it's dumped upon them sometimes to complete DASA reports. And there is little to no information available on NYSED and other websites that's easily accessible to help them with this process. So I'm going to just ask, Brett and Art here informally, if you're aware of other folks that have good samples and do some kinds of trainings around that, let me know too, because maybe we can do something going forward, because I know that there's a lot of need that gets expressed around, okay, we're supposed to do this really important report and we don't know what we're supposed to do. We'd love to look at some models and examples. So
right. Yeah, absolutely,
great
Karen.
question.
It's unfortunate too, because it really should be a district uniform report, right?
Yeah. Oh yeah. It's a whole.
Yeah, and that doesn't help us much to say, oh, well, the district didn't provide it to me. So, right, we still have to do it, right? We're still tasked with conducting that prompt, fair, thorough investigation. So, great point. We can definitely look into that.
Thank you.
Well, there was one more question, Karen. The question was, suppose the child's recalcitrant in answering questions and basically refuses to answer questions without the parent being present. I would suggest to you that I would push the child as politely and respectfully as possible, that you do not have a right to the parent being present. You must be able to answer the questions we pose. And if you don't, your silence could be construed in certain ways that, we wouldn't do if you were forthcoming.
Yeah, and too, I think you've brought up cultures differ district to district.
Oh yeah.
And in some districts, for very good reasons, the recommendation would be to have the parent present to avoid things that are misconstrued, misinterpreted, or just lied about afterwards. So it depends on the district. And I think if there was so much great information here that was presented. Thank you so much, Brett and Art. A couple of big things I think we're taking away is, one thing, don't operate in isolation. Keep your colleagues close, your in-district mentors. Talk to them when you come up against volatile situations or things that need a more formal investigation. And also, something that Art and Brett repeated several times, it's extremely important, and it goes along with not operating in isolation. Tell the superintendent if there's a question about the volatility or impact of a particular situation, if it doesn't feel run-of-the-mill day-to-day, it's another vaping thing, or it's another he said, she said, or, if it really feels to you like it rises above that, inform the superintendent. And I'm going to say too that, once again, cultures differ in districts. The incident that Brett and Art shared about the case of the student at the sleepover that went to the level of a teacher and a board member's involvement, in districts that I have been fortunate to work in, a superintendent would never let the principal conduct investigations with board members, for example. That would rise to the level of an investigation on the part of the superintendent, but that's not true everywhere. There are districts where a superintendent would rather shirk that whole thing and have you kind of out there on the line, delving into something as politically volatile as that one, a board member and a teacher. But that doesn't mean you should do it. So I'm going to wrap up here by coining a little phrase, and the phrase of the day is, if in doubt, give Sainies a shout, okay? If it really feels uncomfortable to you to conduct a certain kind of investigation and you have relayed it to the superintendent and it's still coming back to you, just give us a call. That's all I can say. Brett and Art and Trevor and others are available to help you with everything, every single day at Saney's. So if in doubt, give Saney's a shout. I think I'm going to have to make that a real slogan. But anyway, thank you.
I like that.
I like it, Karen. That's great.
I like it too.
Hey, Karen, one thing about that. When you're consulting the superintendent, and this is what a superintendent told me for the people who left, if you don't memorialize it in writing, if it's not in writing, it didn't happen. So
absolutely,
confirming email. Absolutely. All right, everybody. Have a wonderful evening.
And before we cut out, once again, thank you so much to Brett and Art and all of you for being here today. And on another topic, if you want to find out 10 ways that you can use generative AI right now to make your tasks as a school leader easier, come back February 7th. 10 ways school leaders can use AI apps. Whether you know Zippo about AI at this point, or you've already gotten your feet wet. It's going to be a great workshop. All the details, there it is, right there. See, I said it and it appeared. Thank you, Michelle. Check it out on the website. February 7th, 10 ways you can use AI apps right now. It's going to be awesome. Thanks again, guys. Everybody have a great evening.
Yes. Good night.
Everyone.
Good night.
Bye.